Hmm.
I am praying for listing of the upgrading of this matter at 63 at 2 p.m. is possible.
Right.
Regarding the IA that we have filed, there's already a document passed and lost in our favor. Now, this is regarding a bank guarantee that was told to be encashed. Now, what has happened was the interim order was passed immediately.
I remember
Yes, sir.
they are not releasing it for some interim order has not
Not the
been done.
interim order that was initially passed, pending the bank guarantee. So I filed an array, consequent kindly pick up matter at 2 p.m.
Okay.
63. All right. For listing of an IA ballot, I filed the IA for certification of local voter ballot. What is happening in this case, I filed an arbitration case ballot regarding the compensation ballot. And arbitrator was used to grant me the local demolish voter ballot. And there was subsequent voter ballot, by which ballot the officer of the city government was directed to assess the market value ballot. What ballot the National Highway Authority has come to the same dead part of the order ballot, to demolish ballot. So, my lord, if this order is coming to effect, the subsequent order can be first grade ballot, and my assessment cannot be made, my lord. So, I want modification only to the extent, my lord, that it can be removed only after the assessment done by the officer in terms of whatever the limit permanent arbitrator.
Why?
Because, my lord, once the assessment is being not made, my lord, it's demolished.
No, I remember that matter. Now tell me, you had filed an application for what? For enhancement of your house. Meaning thereby you are not challenging the proceedings. I am challenging the proceedings.
We are challenging the amount of compensation.
So you are only asking on the
Yes.
quantum.
Quantum, my lord.
But by virtue of section 3D, the property already vests. If the property already vests, then where is the question of you that particular not to demolish?
The assessment that has taken made, my lord. The assessment, my lord, was not proper, my lord. That's what we have made in our.
Understood. Very well. Now, Mr. Alam, you are entitled to whatever you have got, you may be entitled to more amount. There's no quarrel with that petition. But the only thing which remains, why I have fixed the matter on the next day. On the first day itself, the repetition of to have been allowed, but I kept the matter pending so that what has happened, the divisional commissioners are no longer there. So the state government is now going to appoint. State government is going to appoint some revenue officers. So till the revenue officers are not appointed, nothing can be done. I fixed it on 3rd or 5th of October.
Yes, sir.
I remember that. So under such circumstances, the question of not demolishing does not arise. The court could, that arbitrator couldn't have passed that order.
If the assessment, what the order has been passed by the arbitrator, for the market value. Therefore, we have question to that, because the amount that has been, because we have given the regulation of the private builder also, which along with the court. So, if the rate, has to be enhanced,
You will get that money.
but without assessment, how will it?
So unless the state government appoints, because you see, NHDCL or this year. Yes, Mr. Talukdar, come here. This is the matter where you moved. I granted an order to demolish it out there. Have you demolished? But the matter has been only kept pending for your review, so that some arbitrator can be appointed. But otherwise, the question of the arbitrator giving an order for that doesn't arise, that state. You can't have that. Impossible. But you want it, only thing why I want it after a few days, only for the reason that in the meantime, the state government can take up a call and appoint an arbitrator. You appear, I can take it up, but again, the matter will be deferred that date so that we can get something to it. I want to say, but you want to do it on Wednesday, so we'll take it up on Wednesday.
Okay.
It's okay. You have demolished it. Understand? No, the question doesn't arise. Only reason why I've kept the matter pending is for the purpose of you appearing. You are respondent number 567. And one is respondent number 10. And the others is 10 to 13.
He has already received they are about 1 crore.
He wants more money. But in effect, it won't help it.
Yes.
Only thing is we require the state government to appoint somebody immediately so that your thing can be decided. You'll have it on Wednesday or Friday. You want to do it today? No, you want to do it today? Well, take it to today. No problem. You can. There's no quarrel with them. But the question of stay doesn't arise. Unless you challenge the entire proceedings. Are you challenging the entire proceedings? Which you are not. Because your application, which has been enclosed in the Annexure 1 to the writ petition, makes it clear that you want more money. So you are agreeable to the acquisition. If the measurement is wrong, everything the arbitrator will decide. So what? Huh? Huh? So you will have it today. We'll make it very clear that the before demolition they'll take photographs. So, Mr. Alam, the fact is, if you want, I can take it up today or not. But the faith is the same. If I take it today, it is better for you because tomorrow, Wednesday, property may not remain. Because this court has allowed them and they are in a hurry. And the moment I allow your application, Mr. Talukdar may very well insist upon these people to demolish to make your IA infructuous. Huh? Today. Okay, 2 o'clock. Mr. Talukdar, get your file. You are appearing for personal appearance? Okay. Item number 10. Okay, to be listed after future vacations. At the request of the Learning Council for the petition. Mr. So-and-so, the Learned Council, appearing on behalf of the petitioner, submits on instructions that the petition has already is infructuous, for which he does not want to press the same. Accordingly, the petition therefore stands closed on withdrawal. This is the matter before any other court. 20? Yes. Why? You are responding?
Yes, sir.
You have filed your affidavit?
Yes.
You have informed the other side?
Yes.
Okay, to be listed after 4 weeks at the request of the Learning Council for the respondent number 1, 2, and 3. Who? It's a 2015 matter. I'm not going to it. Sorry. No. That is very subject to, no. Huh? So there are many other lawyers. Why do you need any other lawyer? We'll have it. No adjournment over 2000. We'll see. No, it can't be at your convenience. These are 2015 matters. 2018, 20, 21, it's okay, understandable. But 2015 to adjourn it and to be fixed on some other date, not possible. Sorry.
I'm on behalf of Mr. Dinesh Shekhar. If I recommend item number 41, may I pray for adjournment for the day?
41, 2015 matter.
He's
Why?
out of his station.
Admission. No, we'll see why the matter has come up for orders. No adjournment.
Item number 23.
Hmm. 23, Mr. D. Chaudhary appearing on behalf of the petitioner submits on instructions that the repetition has become infructuous, for which the repetition stands closed. This interim order, if any, stands vacated.
Item 51.
Hmm.
Order is subject to public. 51.
Mr. Emma Andakar, the learned counsel appearing on behalf of the petitioner submits that the order for which the contempt proceedings was initiated has already been complied with, and as such the petitioner does not want to press the instant application. Taking into account the said submission, the contempt proceedings stands closed.
So item number 54.
You have to inform the other side. At the request of the learned counsel for the petitioner, matter stands adjourned for 4 weeks.
Under item number 37, allow the matter to come for discussion. 37.
What is it,
The matter will come
Mr. Your name?
to
Mr. K. Mohammed, the learned counsel appearing on behalf of the petitioner submits that he has instructions that the instant repetition had become infructuous. Accordingly, prays that the repetition be closed. In their view of the matter, the instant repetition stands closed as it has become infructuous. Huh? The learned counsel for the petitioner seeks for an accommodation for filing an affidavit in reply to the affidavit filed by the deputy commissioner. List the matter for 4 weeks. Yes, Mr. Bhuya, you want to withdraw? Item 1. Withdraw to member.
Number 1, hold the one. Followed by instruction.
Mr. A. Bhuya, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant petition. Accordingly, the instant petition therefore stands closed on withdrawal interim order if any stands vacated. Yes, personal appearance, which matter? There is a direction. I don't understand why, what is the problem? You are the ADC, was I? Hmm? Okay. Now the payment of the amount has been made by the railways as far back as in the year 2017.
Yes.
Then why haven't you paid it to the petitioner councils, to the petitioners? And when the your advocate informs whoever, the ADC who was, and you don't give any value to such information directing you to file an affidavit.
Will be really important for the next year. On our part. The letter was actually done for, and by the time I was out of station for my business. By the time I came back, it was only for some.
In the affidavit, we have shown.
But that is not what has been implied to this court on the last occasion.
Correct.
We have been informed very specifically that there was the order was sent to the ADC Hosai, and he was very well specifically asked to file an affidavit on the basis of the order dated 7/8 or 9/8. But then also you have not taken anything. Whom do we believe? Do we believe the lawyer who was appearing? Where is Ms. Sharma? She had made this specific statement before the court that he was specifically informed about this thing.
Even when the records are come, but the records are not here. But now we have filed the affidavit that amount of the disbursed to some of the petitioners, but out of 24 petitioners, 14 have already received. And the other petitioners, they are not accepting it. But that is why it now is here. So altogether 43% are there in this particular negotiation process. The others, the rest of 50% they have already received. And among the petitioners, 14 have received in our.
Where is the affidavit?
That
When did you file?
today, in the morning.
That has not come on record.
I have.
Okay, as he has filed the affidavit, we will dispense with him, but we'll take up the matter during the course of the day sometime. Let him go, because I don't want an official to be here unnecessarily spoiling. Mr. DC, this court normally does not call any person. Because we know that you have a lot of works. But if you don't comply with the orders passed by this court, and that is, we have no other option but to do so. You are paying for a petitioner in this matter? Where is Mr. Sen? We'll take after some time. Ask him to be here at around 11. Mr. Deputy Commissioner, you just wait for some time. We'll take it up at 11. And you have a copy of the affidavit? Ask your persons to give me another copy of it. Take your matter at 11. Number 2, promotion. Huh? Whom you have not made a party? What is the direction? So whom have you made parties? Where, but Mr. Counsel, where have you issued the notice? When have you issued the notice to these people? Where is it? No, if you don't bring it, how does the contempt proceedings lie? Sorry, we can't initiate a contempt unless we know that you have informed them. How can we? You see, the contempt will be only when it is willful. Willful means they have to know that they have to comply, and then they don't comply. But if you don't show that, how can this court be privacy satisfied about this thing? You have not enclosed that. You do one thing, again submit another representation. Withdraw this, file a submit a representation and then bring it on record. And the period under which it was given is how much? 4 months. Thereafter you appear, file if you find so. The learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant repetition, instant contempt application with the liberty to approach the concerned respondent authorities who were directed by the order dated 21/6/2019 in WPC number 3831/2019. Custom. Taking into account the above, the instant contempt procedure, this court further, upon perusal of the contempt application, did not find that there is any document to show that the petitioner had approached the contemners, the respondent contemners, the alleged respondents, the respondents prior to initiation of the instant contempt application. Under such circumstances, the contempt application is not maintainable, for which the same stands closed. Be that as it may, the petitioner is given the liberty to approach the concerned respondent, the concerned officials who have been directed to pay the amount to make verification and pay the amount to the petitioner. Full stop. They further made clear that the dismissal of the instant contempt application on the ground of maintainability shall not preclude the petitioner to approach again if the order seeking compliance is not complied with as per the terms directed. Yes, Mr. Sikdar. Compensation for what?
For landing.
Why is this petition pending before this court? Just one. It is degree they should give this.
Last we have received a foundation dated 16/5/2020.
But Mr. Sikdar, tell me, award has been passed? Award has been passed or not? You have not passed an award?
No, my lord, it's from the reply department, my lord, that is from my lord.
No, have you passed an award or not? I'm asking you a simple question. Now, once the award is passed, how can this court direct the deputy commissioner? Tell me, under what provision?
Bond has not been was not given despite
Huh?
despite bond has been given because
Mr. Sikdar, matter is very simple. I don't know why this matter is pending for the last 9 years. Simple. Award, no, first tell me, has the award been passed? Madam says that the award has been passed. If the award has been passed, can this court direct the deputy commissioner, who has now become functions official, to redetermine? Has to be done before a reference court. Where is the award? Where is it mentioned that the award has been passed?
Speaking order that
No. Now, are you going to ask tomorrow, this court passes an order? Matter is ends. Just for example, this petition, I pass the order. Thereafter I become functions official in this matter. Now, can you ask for a direction from the deputy commissioner, from the division bench out there, and say that this court be directed to again pass an order? No, unless that order is not set aside. Where is the award? This is done under which provision? Act of 1964. Under what provision? Oh, here there is one communication of the year 2014. That award of LA case cannot be approved unless the estimated amount is deposited within the stipulated time frame. This is done under what provision? 1894. 1894, if it is the award, which have you passed the award? No. So now it will in view of the delay, putting that amount, if the award has not been passed within 24A apply. Have you taken the possession? Under what, 17? Huh? Possession has been taken. How much amount you have paid to the petitioners? You have not got a single penny. How did you pay? So the award has not been passed. No, very about the declaration. The declaration has become useless. Couldn't 11A come in? Now you have to initiate afresh. Mr. Bhattacharya, I am not on anything. You have issued this is done under 1894. Section 4 notification has happened. Then you have done under Section 6. Section 6 you did it when? You have done it in the month of August 2014. So at August 2014, you have the Land Acquisition Act 1894 with you. Where is it? No, where is it? You don't have it with you. Hey, এখন যদি আপনি-
apart from all, consider this current part of, if the provisions of law have not been adhered to, definitely this could be taken or further this to better, further procedure as specified.
No, there's no procedure out there. It is the mandate of law. There's no procedure business. You are to do it within 2 years from the date of the declaration. Then understand, if you have not done the award, the matter has already become infructuous for that purpose. The land acquisition proceedings has already lapsed.
And my own on the state for a moment,
When are you handing over the land and giving them the compensation for requisition?
now, and the minor parties have agreed upon, but in my respect to submit the connection, and a procedure has been made up. Now, blackly only might have carried it on in compliance with it. Nonetheless, the parties have agreed upon that a particular amount of quantum has been assessed. And the Brahmaputra board is not supposed to pay that amount. It is only because of the fact that Brahmaputra board is not paying the amount. Therefore, my lord, it got paid. Consider for a moment, my lord, for my satisfaction, not even I need to take up the case.
For what? No, first you satisfy me how these proceedings can remain. Then matter ends. You have to pay them the requisition amount as per 48.
And the also not been utilized. That is not-
No, that will come under 103 for the new act. We are not concerned with that. But here, I will take care of it. English Indian 1894. Give it to him. Give it to him. Here's a copy. 1894. Yeah, move on. A. How do you save it? Tell me, 11A. This is by operation of law. Then nothing remains. You have to return the land to them and pay them whatever the compensation for unnecessarily harassing them. This will be done on the 48th or 50th. Completion of acquisition and not to compulsory completion of acquisition not to but a compensation to be awarded when not completed, except in cases under 36, the government shall be able to withdraw from the IMAN. Where the government withdraws from any IMAN, the collector shall determine the amount of compensation due for the damage suffered by the owner as so and so and so and so. And okay. You want the land back?
But the land is there, my friend, do not pay, my lord. Then you may be-
You want the land back? You have to get the land back because the acquisition has lapsed. So under such circumstances, you have to get back the land. You have a claim as regards that the deputy commissioner will decide and the government shall pay. That's all for those amount for unnecessary taking this for the last so many years. Or instruction. So, no, and as of now, can you do that? By operation of law, it has lapsed. If you want that this court should hold that 11A has become non-applicable after the Act of 2013, it's a different aspect. For that, you need to make submissions.
But then again,
Huh?
we cannot now divide the situation. That is the difficulty.
Revive what?
For 1 year, it has already ended. By operation of 24 also might have its proceedings. Cannot be divided because 1 year has already ended.
What do you have 1 year?
But on the 20 in the month of August 2014, that declaration was made. As on date, might not no award. No award. So by virtue of consent inequality, this will 24 also. This will, but if the imagination and draw the inference of 24, there also I am not protected. I cannot be used. Because award gets such today.
No, if we go by 24A, 1A, it categorically says that the proceedings shall continue in terms with this Act of 1894 itself. Only the determination of compensation shall happen otherwise. Now, how can these proceedings continue in view of 11A? So by virtue of this provision, it has already lapsed. So you are to return back the land to them.
On the date of taking of one of possession.
And that is also illegal. You couldn't have done that. Now, how could you do it when did you take over the possession? So 2014, if you have taken over the possession, you did it under what provision? 17. Now 17.4, what do you do with 17.4 then? No, these people have been deprived for so many years. What are these land for? So they have been, what did you cultivate? So petty, how many, every day, every year, how much they were entitled to petties? You will decide, you file your application for that. We set aside this entire allocation and give you the liberty to approach, and the deputy commissioner shall consider the amount and the shall do so in terms of 48. That is the only way out. I don't understand why this matter has been dragging out here.
All these evidences are not clarified by the
Yes. First of all, your people, they don't understand head or tail about the law. As regards the Land Acquisition Act, 64 Act, 2013 Act, they didn't know. For them, we are paying them market value. We are paying them 20%, 2 times the amount on an account of solation. So what grievance can you have?
Almost all the cases, I would say why not 97 and 8% of the cases. When the beneficiary doesn't pay the amount, that is the difficulty.
Beneficiary?
Beneficiary, the one who is the beneficiary, doesn't deposit the amount.
Where?
But the awarded amount under the
No, then how do you do it in view of section 6?
Then 6 minus that That 22 section is there. After that,
No, Mr. Bhagare, kindly see section 6(3). How do you do that?
next time when you come to see the section, so that it's very clear. Then some
No,
other-
no. Yeah. 6(1) first provision.
Provided that no declaration in respect of any particular debt covered by notification under section 4.
No. Provided further that no such declaration shall be made unless the compensation to be awarded for the property is to be paid by the constituents or wholly or part of the Iman to the local authority.
This is not, that is the.
That is why
that is
you cannot make a declaration when it comes to a company. That is the problem.
the-
And nobody is seriously fighting a case under 64. What you are doing under 64 is absolutely illegal. You have what you have there. What is the state government doing? There is the 2013 Act. There are a lot of other things to be done. So what we do, we forget about 64. This 2013, the procedure will pay them the compensation, and as such, all the procedural safeguards which have been made under 2013 Act would let us not take it. But how do you do it in view of the specific provision that Act of 2013 supersedes all other acts? How do you do it? That is how the state government is doing.
In fact, the central government has also come up with that Kharak scheme. Thereby might not, using all the procedure and might not, technically, and going for direct purchase.
Go for direct purchase. You are not doing that. What you are doing is we'll adopt 64.
Now,
And nobody wants to fight. Okay, we are getting some money. They are not doing it. They are not bothered with it. And this is how it is happening. And that matter, which I passed an order, that matter has gone for a 6 year, and I'm told that that went in the favor. That is the sad part. The litigants are not fighting it properly. Okay.
you can be very small and not very submitted, I want that much in person.
Hmm?
They were just something personal.
This fund is as per the new act. This fund is as per the new act. You have determined the compensation as per the new act.
Therefore, draw minor attention to the additional ability. The additional ability is minor there is the minus of making what has been done as part of set together. But I am indicating whether there is MXR is 4 for the additional ability. The minus of meeting here done.
No, Mr. Bhattacharya, when are you paying to them? Have you passed the award? How can you make the payment to them without an award? Tell me. You may and pass an award in terms with section 12(2). See. Of the old act. No, not 12(2), 11(2). 11(2). 11(2).
Yes, professionally, anything containing subsection 1 is at any stage of the proceeding. The collector is satisfied that all the person interested in the land who appear before him have everything lacking on the matters to be included in the award of the collector in the form prescribed by rules made by the advocate government. He may, without making further inquiry, make an award according to the terms of such agreement. Now, here, my lord,
If you want to do it, you can do it in that manner where they are agreeable. But this court, Mr. Sikdar, cannot pass an order what you are asking. This court at best can stay and set aside the entire proceedings. If both of you agree, do whatever you like, that is your lookout. I'm not on that. But this court cannot say that this you can pass an award after this. They pass an award, you agree in the terms with 11(2), that is okay, very well, fine. Why should this court say anything about what you people?
therefore, what I- therefore, what I submitted, but the table agreed upon one. Okay, and it's a game, my lord.
Third, how can, you see, how can they agree upon? Can you, as of now, pass an award, legally speaking? No. The proceedings by operation of law has lapsed.
Yes, my lord, that is-
So under such circumstances, you cannot. The only thing is that if they agree, they withdraw the petition, that's a different thing, this court would not touch. But if this court is to adjudicate this matter, this court is going to do this. 11(a). Goes for a 6. So both of you may have a golden handshake amongst yourselves. Don't, and this court will not see all these things and would not touch this matter. But the moment this court has to touch this matter,
It is already a part of the report. That's what I was saying.
for what?
My lord, it is agreed upon all the parties have agreed upon the contract.
Have you passed the word? Then let them agree whatever may be. Have you passed the word? And then they agree upon and then you pay it. And this court then may say that he may withdraw it. That is the only way out.
And my lord,
Or you may try the luck before any other court where for 2000, no, he may. From 2014, it has been lying out there for the 9 years before other courts. So it may do it, some other court may do it. But this court's conscience does not appear that it is going to in any manner say that this is a, you may have an unholy Lexus, you may do whatever you like, that is your. What do you say, Mr. Singh?
My lord, I'm giving you the options.
No, you can't leave it to me. The moment you leave it to me, I will set aside the entire proceedings. Because at that point of time, when you filed it, it was okay. But now by operation of law, it is no longer there. You filed the petition in 2014. It was fine. But now, By operation of law, that proceedings in view of no award being passed, nothing remains. You may acquire it again. Agree to do so, but you do it, the moment you do it, then the price will go up. No, the government has lots of money nowadays. Brahmaputra has crores and crores and thousands of crores. So the government can pay. These are only 143, 144 petitioners. So for them, for the government, it will be peanuts. So no, not only that, you need two more things. The petitioner has to withdraw the petition. Or you may, both of you may say, that taking into account this court's views, this court may not like to take it up. These are the two other ways. Otherwise, this matter cannot, this court can't pass an order saying what he is asking for. This court will have to set aside. The moment it sets aside, the price is going to go up. It's Mr. Sita was. You want the price to go up? Why should I? That is your lookout. Isn't it your lookout? Why should this court make unnecessary observations? How much time will you take to pass an award? They have already agreed upon. Money you have already got it. Now, how much time? So that they withdraw. Absolutely no. I will only make the submission that Mr. R. Borpujari Lego. Mr. R. Borpujari, appearing on behalf of the Revenue Department, submits that there is a process of negotiations going on between the parties, and as such, some time is required. This is the matter of the treaty. That is the only thing, nothing more than that. And you make it clear by showing him the video of today's proceedings. He will understand what is the consequence. Yes, Mr. Nath.
Timing item 20.
Yes, Mr. Sen. Some of the petitioners have got some money. Anyways, some petitioners have not taken the money. Why you are not taking the money? What is your problem in taking the money? You can always take the money under protest. Do whatever you like. Let us assume they are going to pay you 5 rupees, you are supposed to get 10 rupees. So then you can very well make an application for the purpose of enhancement. What is this matter going to help you out here? If you are getting the money, why you are not taking the money? Huh? Let them do it, whatever. Can't you challenge it? Can this court look into what should be the valuation? No. That has to be done before the reference court. Prima facie, no prima facie, this court is not going to do all these things. That is not the business of this court to do so. When there is in the proceedings, it is given. Are you saying out here that this court should do that? No, then if that is so, we'll dismiss your petition, then do whatever you like. Under protest, you receive it. This is done under what provision? 2013 Act. So you take it under protest, move on to 64. You have passed the award, Mr. Deputy Commissioner. You have passed the award. When was the award passed?
2017.
2000? Yes. Who are the petitioners who have not received it?
The petitioner number 1, 2, paragraph 4, file number paragraph 4, 7, 20, 21, 22.
No. Petitioner USA has already disbursed the land acquisition compensation to the petitioner number so and so. And they have duly received the amount, the details of the amount, name of the petitioners are so and so. The petitioners, the petitioner number so and so refused to receive the amount, so the award, deponent could not disburse it. The deponent is ready to disburse the amount. Okay. How many petitioners are here?
24. 24, my lord, out of 24, my lord, 1, 2, 3, 4, 5, 7, 20, 21, 22. My lord, did not receive.
It's okay. You apply, you submit your bank details, you will get it. And then you file it. Because the award has been informed to you. No, notice doesn't say. Let us see the notice. No, Mr. Nath, where is the notice? No, Mr. Nath, where is the notice? Because there is a reason why I am saying. Where is the notice? Huh? Page
47, initiated they include notice under 38 without. Thereafter, without from page the 51 onward.
These are not notices for payments.
No.
These are notices for social impact assessment. When did you give the notice?
Payments for payments and such has not been given, but they were all for hearing because some joint orders are here, but they did not respond to that.
That is okay. That is okay. We are not concerned. But when have you informed that about the award? And where is the award? Because there is a question of limitation. No? Where is the award? You have done not under the 13 Act. You have done it under the 64 Act. The calculation is different. That is why I am saying. Because initially you started with the 13 Act. Because you went for the Section 4, the social impact assessment. Yes.
I find some technical after going to the
No, you have initiated and paid the compensation in terms with the 13 Act. Some of the petitioners have received it and some have not.
They have received in paragraph 4, we have shown how much they are.
You are aggrieved. If you are aggrieved with the compensation, you move under that. Let me dispose it of. The instant petition has been filed by the petitioners. Who are 24 in number, challenging the requisition challenging the notice dated 24/5/2017 issued by the Deputy Commissioner Hosai Sankardev Nagar for requisition of the land belonging to the petitioners covered by DAG number 612, periodic patta number 14, as well as DAG number 614 of periodic patta number 13, situated at Hosai town in the district of Hosai, Assam, as well as also for a writ in the nature of mandamus, directing the respondent authorities to pay appropriate compensation to the petitioner and also to provide rehabilitation to the petitioner for acquisition of their lands as provided under right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. For short, the Act of 2013. From a perusal of the same petition, it does not transpire that the petitioners herein are aggrieved with the acquisition so made. However, the petitioner is only contesting the filing, filed the instant petition on the ground that the acquisition should be made in terms with the act, the acquisition should be, the payment of compensation should be made in terms with the Act of 2013. It is further relevant to take note of that the respondent number 2 had filed an affidavit in opposition, wherein it has been mentioned that had filed an affidavit in opposition, as well as also an additional affidavit wherein it has been mentioned that as per the estimate so provided by the office of the collector, Hosai, an amount of rupees 4,55,66,961 was sanctioned and was issued from the GM/CON/MLG by S/MC number 76 land 2017 dated 4/8/2017. And pay order has also been issued in favor of the Deputy Commissioner Land Acquisition Branch, Hosai. It has also been mentioned that as far as so far the list of beneficiaries is concerned, it lies within the domain of the Office of the Deputy Commissioner, Hosai. This court further finds it relevant to take note of that by an order dated 9/8/2023, this court had directed the additional Deputy Commissioner in charge, Hosai, to produce the records of LA case number 1/2017. And further, the officials was also directed to ensure that in the records, the list of beneficiaries were there. And accordingly, the matter was fixed on 25/8/2023. However, on 25/8/2023, the Learned Counsel appearing on behalf of the Deputy Commissioner, Hosai, ADC Hosai, submitted that there had been no instructions received inform this court. However, on 25/8/2023, Ms. S. Azurika, the learned counsel appearing on behalf of the railway, submitted that in pursuance to the estimate given by the Deputy Commissioner and the Collector Hojai, an amount of rupees 4,55,66,961 for acquisition of the land measuring 2 bighas 4 kata 15.79 lesas of village Hojai, town number 1 and Hojai, town number 2, Isam, under Hojai Moja, have been duly paid to the Deputy Commissioner, Land Acquisition Branch by a pay order as far back as on 4/8/2017. On the same day, certain reports were produced by the junior government advocate, Ms. S. Sharma, but this court found that the said records so produced had no relevance to the issue involved. Under such circumstances, this court directed the ADC in charge Hojai to file an affidavit by 7th of September 2023 as to how much amount have been disbursed to the petitioners pursuant to the receipt of the amount by the Office of the Deputy Commissioner Land Acquisition Branch Hojai as far back as in the year 2017. It was also directed that the affidavit shall also disclose if no amounts have been disbursed, why so. Accordingly, the matter was directed to be listed on 8th of September 2023, making it clear that if the affidavit is not filed, this court would have no other option but to pass appropriate orders against the ADC Hojai as well as the other officials of the Land Acquisition Branch of the Office of the ADC Hojai. Be that as it may, on 9/8/2023, it was informed to this court by the junior government advocate that the ADC Hojai had not responded to her information and given the instructions as sought for, nor has also made himself available for filing the affidavit in terms with the directions passed by this court on 25/8/2023. It is under such circumstances this court had directed so the personal appearance of the ADC Hojai today on 18/9/2023, that is on 18/9/2023 at 10:15 a.m. The Deputy Commissioner Hojai is personally present pursuant to this order passed by this court on 8/9/2023 and had also filed an affidavit in opposition. This court, upon inquiry with the Deputy Commissioner Hojai, was informed that he was not, that the order passed by this court directing filing of the affidavit was not informed to him, and as such, the order passed by this court on 25/8/2023 could not be complied in letter and spirit. He, however, submits that in future, the Deputy Commissioner, the Deputy Commissioner Hojai shall be more cautious, alert, and will take steps to ensure prompt response to this court's matters. The said aspect of the matter, in view of the said categorical statement being made at paragraph number 2 of the said affidavit filed by the Deputy Commissioner Hojai, this court duly accepts the apology and dispenses with his personal appearance. This court further takes note of the affidavit so filed by the additional Deputy Commissioner, by the Deputy Commissioner Hojai, wherein at paragraph number 4, it has been mentioned that the petitioner number 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 23, and 24 have already been disbursed with the compensation and they have duly received the same. However, the petition number 1, 2, 3, 4, 5, 7, 20, 21, and 22 refused to receive the compensation amount, and as such, the said amounts could not be disbursed. The legal counsel for the petitioner, Mr. B.K. Sen, submits that he would now instruct could not be disbursed obviously. It has been also mentioned in the said affidavit that the Office of the Deputy Commissioner, Hojai, is ready to disburse the pending amount if the petition numbers 1, 2, 3, 4, 5, 7, 20, 21, and 22 approaches.
Petitioner number 8, 19, 23.
Wait, Mr. Sen, I will listen to you. Wait, Mr. Sen, wait. Would receive the state petitioner number so and so agreed to accept the same. Yes, what are you saying now?
The petitioner number 8, 9, 23, and 24.
Hmm.
They have received partition for the entire.
How do you say?
They have said so. And this is my instruction. Because they have only got the Mellon house part, the well house, fees, etc.
Understood. Mr. B.K. Sen, the learned counsel appearing on behalf of the petitioner, submits that although some of the petitioners have received the amount, but they have not received the entire amount to which they are entitled to. He further submits that he would instruct the petitioner, the rest of the petitioners, that is petition number 1, 2, 3, 4, 5, 7, 20, and 20, 21, and 22, to approach the office of the Deputy Commissioner by filing necessary applications for receiving the amount and accepting the same. Under protest. Upon hearing the learned counsels for the parties, this court is of the opinion that the petitioners, that in view of Section 12 of the Assam Land Acquisition and Requisition Act 1964, a person who is aggrieved by the inadequacy of the compensation has a right to file an application before the collector seeking a reference to the court. And Section 12(1)(a) categorically mandates, it categorically imposes a statutory duty upon the collector to make a reference to the court as defined under section. You got that act? You are appearing without that? What act? What is defined under section 2B or 2E? Under section 2B or 2E, up to 1964. This court further finds it relevant to take note of section 12(2) of the Act of 1964, which stipulates that by legislation, which stipulates that by virtue of legislation by incorporation, the provisions of the Land Acquisition Act 1894 have been incorporated to a reference to be made under section 12(1) of the Act of 1964. Under such circumstances, the provisions of section 1819, 31(2), bracket 2, of the Land Acquisition Act 1894 becomes applicable in respect to such applications so filed by the petition, in respect to applications filed seeking reference. This court further finds it relevant to take note of that section 31(2) provides, or 31(2) of the Act of Land Acquisition Act 1894 provides that the beneficiary, that the person to whom the compensation is paid can receive the amount under protest. So, taking into account the above propositions, this court therefore disposes of the instant writ petition, thereby giving the liberty to the petitioner numbers 1, 2, 3, 4, 5, 7, 20, 21, and 22 to file appropriate applications before the collector Hojai for getting the compensation. It is made clear that if the petitioners are aggrieved at the inadequacy of the compensation, all the petitioners are aggrieved by the inadequacy of the compensation, the petitioners would be at liberty to file such application within 30 days from the date of the instant order. Shall be at liberty to file such applications. You file it within 30 days because I am fixing it, because otherwise they may later on cause some problems. So within 30 days from the date of the instant order. And if such applications are filed by the petitioners, the collector, Hojai, shall shall be statutorily bound to refer the same to the court in view of the provisions of section 12(1) of the Act of 1964. So with the above, the instant petition stands disposed. Certain the documents, the additional documents so played by Mr. D. Nath, the learned senior government advocate, is kept on record and marked with the letter X. What?
And they preferred the petitioner arranging the implementation of the codal authority some easier land were allotted in the name of some that is such a review of the system of an example. So this system of
You know the
yes, no, the base system of
right?
base system was the program Rashid approved the proposal for regularization of unauthorized construction of religious institutions under strictly revenue sector of Siran district. And it led in question easier land. So the petitioner being society, registered in the society.
Where is that order of the Supreme Court?
Supreme Court order is lordship. Let us go into the record to ensure lordship. The Chapati.
Certainly, I know.
2011 Chapati was the state of Punjab.
Now, what are you challenging?
What is that it is easier.
No, that is of 24th of April 2012. Now, thereafter, there is another document of 29th of June 2012 at Annexure 5.
It gives its inability to control the proposal to the recent regarding lordship, development of land of Assam Agricultural University. There was proposal from the Assam Agricultural University for having some land in that particular area. That was rejected. But
So you want a similar thing?
this
in your
proposal
case
was
also.
that the GCL land should be protected, lordship. No further enforcement should be there, lordship. That is the there of the petition, lordship. And the legal enforcement. ABM.
Who is appearing for the private respondents?
Hermetic mission was start of.
Why their names have been struck off?
Yes, six start.
Why their names have been struck off?
Later,
7/4/2018.
Already, government,
It's 7/4/2018. एक IAS है इसकी. 11/4/2018. No, Mr. Counsel, how can this court maintain the instant repetition when the counsel appearing on behalf of the petitioner had said that the names of the respondent number 6 and 7, in whose favor it is required to be struck off? Can this court now proceed with striking out after the striking off against the respondent number 6 and 7?
the eviction part is not. The eviction part is not.
No,
Yes,
the challenge.
yes,
The challenge made to their allotment goes without 6 and 7. Then how can this court pass an order? What you are asking? Tell me. You are challenging the allotment made to 6 and 7.
yes.
They are the private respondents.
Yes.
By an own the learned lawyer who was appearing for a petitioner makes a submission on 11/4/2018, heard Mr. H. Hawk, the learned counsel appearing for the petitioner, and also heard so-and-so appearing for respondent number 3 and 4 and Mr. H. Mr. Hawk sought for striking out of the names of the respondent number 6 and 7, which is accordingly allowed. Accordingly, in the meantime, shall file the affidavit. Understood, but can this court pass an order? You are asking for striking of an order in their favor.
Against respondent number 6 and 7, no order can be passed at this.
No, then can this court, no, you are challenging 24,
24, 12 laws.
you are challenging 24/4/2012, which is annexure.
And example,
Yes. Why are you challenging this?
that, land actually number one, somebody 50, 60 and 70 lordship serial number. Particularly this thing, this land comes under. And the number one somebody
Now, in whose favor it is? In whose favor it is?
lordship, in favor of Deepja, it is written as Deepja.
Where?
15, 16 and 17 serial lordship.
So this Giza would be this response number 6 and 7.
6 and 7 only.
So
Then the Giza.
you have specifically mentioned in your petition it is 6 and 7. Then how can you maintain the incident with petition? Tell me. Without 6 and 7. You have to seek a review to that order. Without seeking review to that order, it is not possible. Isn't it?
That further enforcement release. That is the particular. Fair lordship now. For the sake of the community. That no further enforcement may be. No further enforcement. That is it. So.
So you are not challenging the allotment being made. So this order goes. This order you can't challenge 24/4. Because without 6 and 7, it cannot be. So you have to seek you can't ask that you want to take steps against them, so and so. Unless there is a review to the order, their name has been struck off. And if you want future, the law is already there. Why should this court pass an order in view of Chakpal Singh? No case. No. Can't help you.
Communication was involved. After it is. So I am not getting the convention. So one of the finally.
When the names of 6 and 7 has already been struck off, means the writ petition against the respondent number 6 and 7 has been dismissed. If it has been dismissed, can this court pass an order now? Huh?
And it's a court was there in respect of allotment of granting against real estate. Creating a society concerning the real estate in their area. We find it. As a big for stopping this enforcement.
No, but there is nothing against the respondent number 6 and 7.
6 and 7 was also there. They occupied some land under the number 68.
68, which comes under VGR.
Easy.
But that you have, but can this court pass an order against them without them?
Now,
So there goes. So your petition has to be dismissed.
yeah, we have continued started actually.
Yeah.
After the finalizing of the-
Because that order was passed 5 years back and you have been all following it up. I don't understand why the matter has been pending thereafter. Matters have been coming after one after another and all. Every time, who is Mr. Bibi Ahmed, Mr. J. Hussain, who is he? The incident with petition was filed by the petition. challenging the order dated 24/4/2012, as well as also seeking a mandamus directing the respondents to evict the illegal unauthorized occupants from the aforesaid government VGR lands and to restore the same to the common users of the villages, as well as to prevent further illegal and unauthorized occupants to the same aforesaid lands. From a perusal of the writ petition, it reveals that the order dated 24/4/2012 has been put to challenge primarily on the ground that the government DAG number 68, which as per the petitioner is a VGR land, was allotted to the respondent number 6 and 7. However, this court, during the course of the proceedings, it is seen that on 11/4/2018, the counsel for the petitioner had made a submission before this court that the names of the respondent number 6 and 7 be struck off. And accordingly, this court struck off the names of the respondent number 6 and 7. Under such circumstances, in absence of the respondent number 6 and 7, in the opinion of this court, the instant writ petition cannot be maintained to challenge the order dated 24/4/2012. Accordingly, the relief so sought for, challenging the order dated 24/4/2012 and the eviction of the respondent number 6 and 7, cannot be granted in the present facts. Be that as it may, this court also finds it relevant to take note of that the Supreme Court in the case of Jakpal Singh and others versus the state of Punjab and others reported in so and so, have categorically had observed that community lands as well as village grazing reserves cannot be granted allotment. In view of the said directions of the Supreme Court in Jakpal Singh Supra, this court disposes of the instant writ petition, directing the concerned respondent authorities not to henceforth allot any lands, any community lands as well as VGR reserve, village grazing reserves to any private individuals with above the instant petition status. That is the most I can.
I can find it.
Yes. What is this case about? What are you challenging? Not to proceed to transfer by way of lease or sale of the assets mortgaged with it by public auction for settlement of the dues in petitioner without complying with the directions passed by this court in so and so. What is this direction? You are the Assam Financial. You are initiating proceedings under the SARFAESI.
Particular order, the representation was there. And thereafter, the order has been passed. The order has not been accepted.
Huh? Page 20
Another.
of your affidavit. Page 20. Refer to the Honorable God had ordered to settle your loan amount under the NPS settlement policy. As per MD, you are to pay rupees 4,50,000 to settle your loan. You are therefore requested to submit your year. Now, what has happened then? Huh? No. First of all, what is his prayer? Understood. The prayer is only that you should not take any action without complying with the directions. Now you have duly complied with the directions. Huh? Understood. But what is the stay order for that? We have already complied with it. And there is no challenge to this communication. And then the instant petition has been filed by the petitioner, seeking a direction upon the respondent authorities not to take over the possession of the land, factory and collateral security of the petitioner, and not to proceed to transfer by way of lease or sale of the assets mortgaged with it by public auction for settlement of the dues in the petitioner's loan account without complying with the directions passed by this court in its order dated 11/11/2014, passed in WPC number 5595/2017. It reveals from the records that this court, by an order dated 11/11/2014 in WPC number 5595/2007, disposed of the writ petition, thereby permitting the petitioner to apply to the AFC, that is the Assam Financial Corporation, under the NPA loan settlements policy, and the competent authority of the Assam Financial Corporation was directed to consider the petitioner's representation in accordance with their notified scheme. The petitioner was also directed to furnish the copy of the said order dated 11/11/2014, along with their representation within 2 weeks from the date of the said order. And the competent authority of the AFC was directed to consider the representation with a speaking order within 6 weeks thereafter. The impugn recovery proceedings under the State Financial Corporation Act will abide by the decision of the competent authority in terms with the said order. It further reveals that the petitioner had submitted a representation had submitted a representation in pursuance to the order passed by this court. Thereupon, by an order dated 29/12/2014, the branch manager of the Assam Financial Corporation directed the petitioner to pay rupees 4,50,000 to settle the loan account, and requested the petitioner to submit the proposal within 15 days from the date of receipt of the said letter to settle his loan account as per the said package, subject to the approval of the Board of Corporation. The petitioner thereupon, on 8/1/2015, submitted before the chairman of the Assam Financial Corporation that the amount of rupees that the subsidy amount and the one-time settlement payment of rupees 2,03,660 and rupees 55,000 lying with the corporation be adjusted against the loan amount pending, if any, as per the NPA Settlement Policy 2013. Thereupon, the petitioner had approached this court by filing the instant writ petition. It reveals from the records that this court, by an order dated 2/11/2015, issued notice and further in the interim directed the Assam Financial Corporation not to take or initiate any action against the petitioner by way of taking over of the possession of the land and the factory of the petitioner. At the same time, it was also made clear that the said restraint order shall not be subject to the petitioner making a payment of rupees 2 lakh to the Assam Financial Corporation within a period of 4 weeks from that date. It further reveals that pursuant to that notice being issued, an affidavit in opposition was filed by the respondent numbers 2, 3, 4, and 5. Wherein it has been mentioned that pursuant to the order dated 11/11/2014, the petitioner submitted a representation dated 28/11/2014 to the chairman of the corporation, enclosing the order dated 11/11/2014. Thereupon, the order dated communication dated 29/12/2014 was issued by the respondent corporation, intimating the petitioner that as per the NPS Settlement Policy 2013, the petitioner was liable to pay a sum of rupees 4,50,000 only to settle the loan account. And the petitioner was requested to submit his proposal within 15 days from the date of receipt of the said letter to settle his loan account as per the package subject to the approval of the board. It was further mentioned that as no action was taken by the petitioner till August 2015, the respondent corporation decided to sell the takeover mortgage property, and accordingly the circle officer Doboka Revenue Circle, Nagaon, was instructed the concerned land revenue official to record the mortgage property and encumbered in the land records in favor of the Assam Financial Corporation to prevent transfer of the mortgage property in future. However, on coming to know about the letter dated 4/7/2015, the petitioner again filed an instant writ petition before this court on 15/10/2015, and this court passed an order dated 2/11/2015 directing the petitioner to make payment of a sum of ₹2 lakhs to the respondent corporation within a period of 4 weeks. It is also mentioned in the state affidavit that the petitioner did not take any action as a result of which the respondent corporation issued a letter on 8/2/2016 requesting the petitioner to carry out the order of this court immediately. But no action was taken by the petitioner for payment of the amount of ₹2 lakhs as ordered by this court. Finding no other alternative, the respondent corporation, again by the letter dated 24/2/2016, requested the petitioner to pay the amount as ordered by this court. On 2/3/2016, the petitioner paid an amount of ₹2 lakhs as per the order passed by this court dated 2/11/2015. The respondent corporation thereupon, by the letter dated 14/3/2016, formally intimated the branch manager of the corporation that the respondent corporation has credited the said amount of ₹2 lakhs in the branch account of the Nagaon branch of the Assam Financial Corporation. In paragraph number 24 of the said affidavit in opposition, it was mentioned that the petitioner paid an amount of ₹2 lakhs and is yet to pay a sum of ₹2,50,000. The petitioner had also not forwarded his proposal under the NPS settlement policy to the respondent corporation, as a result of which the respondent corporation could not settle the loan account of the petitioner. From the above materials on record, it therefore transpired that the Assam Financial Corporation had directed the petitioner as far back as on 29/12/2014 to pay an amount of ₹4,50,000. The petitioner, therefore, pursuant thereto, by the communication dated 8/1/2015, requested the respondent authorities to adjust the amount of ₹2,03,660 and ₹55,000 lying with the corporation. However, prior to taking such steps, pursuant thereto, the respondent authorities, the said requests were made by the petitioner on 8/1/2015 was not taken into account, for which the petitioner approached this court. This court, while passing the interim order, had made it clear that the interim order so passed shall not. This court, while issuing notice on 2/11/2015, and passing an interim order directing the respondent corporation not to initiate any action against the petitioner by way of taking over the possession of the land and the factory of the petitioner, made it clear that the restraint order shall not subject the petitioner making a payment of ₹2 lakhs to the financial corporation within a period of 4 weeks. It further reveals from the records that the petitioner did not pay the amount of ₹2 lakhs in terms with the order dated 2/11/2015, but had paid the said amount of ₹2 lakhs on 2/3/2016, which can be seen from Annexure 3 to the affidavit in opposition. The question therefore arises herein is as to whether the petitioner would be entitled for adjustment of the amount of rupees 2,03,660 and rupees 55,000, which the petitioner claims are lying with the respondent authorities, respondent corporation, or the petitioner is liable to pay the additional amount of rupees 2,50,000. And the payment paid, the amount of rupees 2 is not entitled to the adjustment as sought for by the communication dated 8/1/2015. This aspect of the matter cannot be adjudicated in the proceedings under Article 2 to 6 of the Constitution. Under such circumstances, this court therefore disposes of the instant writ petition, directing the respondent corporation to decide the communication dated 8/1/2015 to decide as to whether the petitioner herein could be entitled to any adjustment of the amount of rupees 2,03,660 and rupees 55,000, which the petitioner claims is lying with the respondent corporation. Which can be adjusted against the demand of rupees 4,50,000. The respondent corporation shall duly consider the same on the basis of its extant laws and policies and pass an order informing the petitioner in that regard. It is made clear that still such order is passed by the respondent authorities, the respondent authorities shall not take any course of action against the petition. With the above, the petition stands. Madam, I gave you more than one, your senior.
6.
Yes. I have to cut down and approve the 3 members of dangerous standing tree. Tree is lying where? Where are the trees?
It is adjoining land of myself.
Your land.
My land.
Now, whose land it is?
That's for number 7.
So go before the civil court. How can this court decide between you and him? And how are you involving Mr. T. Gogoi?
I am coming to for a direct for removal of the vendor. Procedure followed by these are in kind position and it can for at any time before upon my house. It is a cheat to my life. Therefore, I am coming for this for
It is over your house,
my lord.
on top of your house.
No, in the down. My land is situated at lower level, that would be in the high level.
So it is transgressing into your boundary.
Yes, man.
Cut it. Auntie, cut it. If the branches are coming to his place. Yes. Who? They.
My lord.
Huh?
That is, his actual fact is that those issues were in inclined position. And in this portion of the land, immediately.
No, Mr. Counsel. This is between you and the respondent number 7. Why you are dragging others?
The position issue is that between him and me, who will cut him? I have approached him. He refused. And but when I attempted, I have been debarred. and I have filed my petition, representation before the disaster management authority. By I answer your security. But no action has been taken. I am spending sleepless night in heat of my life.
When? Are you still?
Yes, my lord.
For last
But I have filed it in 2017.
last six years?
Yes, my lord. I am spending sleepless night. So
The
your
last 6
opinion-
years you have not been sleeping.
Yes, my.
Let us see the trees.
Yes,
No, Mr. Council, let us see the trees. Where are those trees? Let's see. Which are the trees? Page 14A. Page 14A.
Some additional facts are there.
Yeah, who are you?
I have eight.
8. Who is 8?
This land belongs to me. There is a big case pending now, but degree has to pass in my favor. And they are in appeal before the academy. And but he has also expired.
7 did.
7 days. Our legal years has been included in the academy.
Now tree has been placed where?
As my land,
And how is he in
he is claiming right in respect of that.
that land?
Yes, and the petitioner says that since he is still in possession, there was some dispute. Possession has now been given. Now. he
You
has-
are in possession of the land now.
Yes,
Okay, so he's out. 7 is out.
7 days.
7 is out. So if the fight is between both of you. Okay, now the tree, what is the fate of the trees now? Let's come to page 14A.
Alright.
Let us also become now the trial court. Yes,
Madam.
which is the tree?
Yes, I got a photograph.
Now, which is your house?
This is house only in the south.
So that is your house.
Yes, ma'am.
And are you saying that the tree is this one, that is just in front of it?
Those also see that those were these lower portions were bounded by me, which is plastic cover. So that rainwater made of was water.
Oh, it is in a higher hill.
Yes,
Yes, why you are not cutting off this tree? What are you going to do with this tree? This tree may any day fall down. You know nowadays with so many things, what will happen to his house?
it is very dangerous.
But then also, Mr. Council, this is not a case under 226.
Well, I am praying for a clear answer to the disaster management authority and this honorable court has passed the order for a report. In the matter by order dated 13/2/2019, but no report has yet been submitted. For your lordship,
13
I have been 13/2/2019.
to.
This is order passed by the honorable court.
Yes, revenue. What is it? Huh?
Forwarded the letter to DFO Council final.
Hmm.
Start of the final.
Cut off the trees.
Yes, sir.
Okay.
Start of the final.
I have a report of 70, it says these are standing dangerous.
Yeah, cut it. What is there? He's under threat. He can't sleep for the last 6 years. Huh? Do something.
But the problem is, it has been passed on my favor. Position has been granted to me. A final second appeal, status quo, order was granted. By virtue of that,
Status quo for what?
status quo as regard the land. And there was a Earlier they used to.
Show me that order.
But past a day later, then the degree was executed by the. And later on, we.
Where is the status quo? In the disposal of the other parties shall maintain the status. Okay, don't worry. No worry. I will say that your apprehension is there in the status quo order. This status quo order shall not affect. Is a status quo order is only as regards the possession and shall not bar you from cutting the tree. But the tree matter is. Because it is his life, concern and idea. This is dangerous. And what is your report?
Say this is dangerous.
Show me that. Give it to this.
Can I say one more time?
Don't say anything. You want to cut or you at his cost.
Cut it a lot.
At his cost.
Yes.
You want to pay.
Standing on his land, therefore,
Now you take the wood.
Hello?
You take the wood. Take the wood. If you cut, you take the wood.
Their legal hands, our legal hands would create problem.
Who's you get?
7.
7 is no longer. 7 is out. 7 is no business. Whoever pays the amount, he keeps the wood. Who of you?
I'm in no need of you.
You wait. Magview is coming.
Nobody is.
He will cut it. Okay. I'll make it clear. The instant repetition has been filed. Because these matters, keeping it pending unnecessarily doesn't help you anyway. Asking for reports and all these things. They are not going to do anything. The instant petition has been filed by the petitioner seeking a direction to cut down and uproot the numbers of trees dangerously standing in the plot of land measuring 4 kathas covered by old Dag number 3, plot number 15 and 16, new Dag number 361 covered by included in KP Patta number 3, situated at Revenue Village, Hagura Guli, Sunsali, Grand Nepali Sok Nunmati of Ulubari Moja in the district of Kamrup Metro, Assam. It appears from the writ petition, perusal of the writ petition, that the petitioner's house the petitioner land is at a lower level, is adjacent to the land covered by Dag number 3 old, 361 new, included in KP Patta number 3, situated at Revenue Village, Haguras Guli, Sunsali Grand, under Moja Ulubari in the district of Kamrup Metro. That's for short the said land. the topography of the said land is such that its terrain is higher than the land of the petitioner. It is also seen from the repetition that in the land of the petitioner, there is a house. It is also seen that there is a dispute going on between the respondent number 7 and 8 over the said land. Which is a subject matter of another litigation. Be it as it may, on the said land, there are 3 trees. And there are there are 3 huge trees. Which the branches of which are hanging over the petitioner's house, and apart from the fact, the trees are standing in a dangerous manner, which may impact, which in a dangerous manner, and in all likelihood, if there is an erosion of any land, may fall upon the petitioner's house. To the same effect, there are certain photographs enclosed to the writ petition at page 14A and 14B. Which also shows that the said 3 trees are standing dangerously on the land, on the said land. The petitioner, therefore, had approached the respondent number who may be approached? No. Respondent number 7 had approached the Revenue and Disaster Management Department to cut down the said trees. Fearing the threat to his life and his property. The petitioner had also approached the Forest Range Officer, Guwahati Range, Guwahati, for also taking steps for cutting down the said trees. The additional Deputy Commissioner and CEO, this District Disaster Management Authority, Kamrup Metro, had also issued a communication to the Circle Officer, Guwahati Revenue Circle, on 25/4/2017, informing about the 3 dangerously standing trees and to take necessary action in that regard. However, nothing has been done in that regard, for which the petitioner has approached this court. Mr. R. Dubey, and who was the other person who was appearing for the other one? For number 7, who was appearing? Huh? Mr. E. Okay. Mr. K. Vechedi appears for the respondent number 7, and Mr. R. Dubey appears for the respondent number 8. They informed this court that presently the respondent number 8 is in possession of the land, said land. But there is an order of status quo passed in IA Civil 1976/2019, arising out of second appeal or first appeal? Arising out of RSA number 117/2019. And as such, the respondent number 8 is not in a position to cut down the said trees. Upon hearing the learned counsel, this court also had taken note of the submission of Mr. D. Gogoi, the learned counsel appearing on behalf of the Forest Department, who submits that on inquiry being made by the forest officials, it was found that the said trees are standing dangerously and in all likelihood may fall upon the petitioner's house. Taking into account the above, this court before deciding, this court finds it relevant to take note of the order dated 12/6/2019 passed in IA Civil 1976/2019, arising out of RSA number 117/2019. From a perusal of the said order dated 12/6/2019, it is seen that the status quo order so passed only relates to possession. And as such, the same status quo order dated 12/6/2019 would not come in the way of the respondent number 8 to cut down the said three trees standing upon the said land. This court therefore taking into account that the life and liberty, taking into account that the said in three trees are taking into account that the standing of the 3 trees being a threat to the lives and the properties of the petitioner grants the liberty to the respondent number 8 to cut down the said trees within 1 month. No, within by October 2023. It is made clear that if within that said period, the said trees are not cut down, who shall cut? Forest. The forest department of the government of Assam, and more particularly the divisional forest officer Kamrup East Division, shall take appropriate steps for cutting down the said trees within 10 days thereafter, with the above the instant petition status. You cut down. Whoever cuts gets the wood. Kamrup East. Yes, Mr. Dave. Eviction under what?
Petitioner is in occupation of Patra land. Not the railway. They are not unauthorized occupants of the railway line.
So,
So but they are the Patra holders.
have any orders been passed by the estate officer?
Yes,
Has the estate officer held that it is railway land?
my lord, their contention, their contention is railway line.
Okay.
But-
Why haven't you filed an appeal?
My lord,
Why should this court decide?
my lord, because petitioner has owned the Patra land. not
Understood.
railway line.
So show it before the district judge.
Well, before the state authority, my lord, Patra was sold. But
Forget about the estate. A state officer may make a mistake. If an estate officer makes a mistake, you can very well file an appeal before the district judge. Why are you doing here?
I am the, that's why my lord.
Now you want to show that you are the owner of the land.
My lord.
Tell me, you want this court to be the civil court. Where is the original patta? Show me. Show me the original pattas.
It starts from page.
No, Mr. Dev. You want this court to be the civil court. I mean, show me the original pattas. You want this court to believe that that is the land. So you want this court to be the civil court. Court fact finding by authority. Then go there. Unnecessarily. 12 days time, Mr. Day, I am giving you 12 days time for filing appeal. Else I am dismissing it. This is a question of fact. How can this court decide? Should I decide on this thing? Yes, this is a patta. When the railways are saying that no, show it before the authorities. You have to prove it. That this is your land. A very good opportunity is being given out there. The district judge, I would have understood that in other cases, if it is the state public premises eviction act, it is the deputy commissioner. But here you are getting before the district judge. What stops you from doing it?
I disagree.
So how can there be a 300A? No. 300A will be only come when a land of yours or any property of yours cannot be taken without due course of action, without accordance with law. That is 300A. Now, when the estate officer is not taking it, the estate officer is saying that this is railway land. And if it is a railway land, then how do you bring 300A? Tell me. Let us assume that the estate officer is right. Now, on the basis of that, you say
Tag number, patta number, etc.
railways don't have dark number, patta number. Railways have a map. Then this is how it is done. You have a periodic patta, so you get a stay there. And this matters. 12 days for filing appeal. Nothing more than that. Forget about last orders. Huh? What? Their affidavit. Whose affidavit? Their affidavit not necessary. What am I going to do with their affidavit? No, therefore I'm saying you have two options. You have to prove before this court that this land belongs to you. Prove it. I'm giving you the time. Prove it. Today. Now, prove it that the land belongs to you. Okay. Patta is there. Let us assume that that is the patta. Now, can you say that the land where notice has been issued is in the respect to the patta land? Can you see that? Can this court ascertain that the land notice which have been issued to you is in respect to the patta land? Or you are in occupation of only the patta land, not their land? Tell me, if that can be done, very well. That can't be done. These are nothing but more mercy petitions. And I give you a mercy of 12 days for filing an appeal. And the status quo will, the status which is being given shall remain till 12 days. That's all. Nothing more than that. Huh? Yeah. I can't help you. The law categorically says that section 9, 12 days. Can I increase it beyond that? No. It is 12 days. So I'm giving you 12 days. You don't do. It is okay. They may evict you, then you may do it. Then also you can. It is only the question where you are. The instant writ petition, how many petitioners? You pay court fee. You have not paid the court fee, you have only paid 60 rupees. 1, 2, 3, 4, 5. 4 years paid. 110 rupees. Only 110 rupees for 16 days. So you want the 12 days for whom? Rest we dismiss it. 12 days for whom? Rest we dismiss it. On the Article 226 should be dismissed. 12 days for whom? Choose any of the 16 petitions. 2. How can they be similar? Everybody has been issued a notice, separate notice. Not really. Is it the same order? Then every notice has a different number. Are you claiming? Are all the petitioners claiming on the basis of one patta? All are under their brothers. Then separate pattas. Then okay. 16 petitioners hearing have approached this court under Article 2 to 6 of the Constitution, challenging the various notices as well as the orders, challenging the orders dated 21/5/2017 and 17/5/2017 under Section 5 of the Public Premises Unauthorized Eviction Act 1971. It is seen from the records that each of the petitioners were issued notice by the estate officer NF Railway, Lamding, under Section 4 of the Act of 1971, asking the petitioner to submit replies as to why the petitioner should not be evicted from the lands under their possession, in as much as, in terms with the said notice, the lands mentioned in the schedule therein were railway lands. The petitioners thereupon submitted certain did not file a reply, but only submitted certain land documents. Claiming that they are in possession of their own patta lands. Thereupon, the estate officer passed orders in terms with Section 5 of the Act of 1971 on various dates on 17/5/2021 and 21/5/2021. 17/5/2017 and 21/5/2000 on various dates. These orders have been put to challenge by filing the instant writ petition. From a perusal of the orders impugned in the instant writ petition, it reveals that the estate officer NF Railway, Lamding, who has the authority and jurisdiction in terms with the Act of 1971, has issued the notice under Section 6(4) of the Act of 1971 and have also passed orders under Section 5 of the Act of 1971. Therefore, as the estate officer, NF Railway, Lamding, has jurisdiction and authority to do so, the said orders cannot be set aside by this court on the ground of being without jurisdiction. The learned counsel appearing on behalf, Mr. P.C. Day, the learned counsel appearing on behalf of the petitioner submits that the facts that the petitioner are actually residing in their own lands for which pattas have been issued, and not within the lands as mentioned in the notice under Section 4 of the Act of 1971, as well as in the order passed by the estate officer, NF Railway, under Section 5 of the Act of 1971. These aspects as to whether the petitioner is in possession of government of their own lands or railway lands cannot be entertained by this court under Article 226 of the Constitution, as the same relates to disputed questions of facts. The learned counsel for the petitioner therefore submits that the petitioner may be granted the liberty to file appeals under Section 9 of the Act of 1971, assailing the orders passed under Section 5 of the Act of impugn orders under Section 5 of the Act of 1971, which have been impugned in the instant proceedings. Taking into account that as to whether the petitioners are in occupation of their own lands or railway lands are questions of facts, and the first and the appellate authority, that is the district judge, which one was I? Karbi Anglong? Where is the land? Difu. Taking into account the district judge Karbi Anglong shall be in a position to adjudicate the said questions of facts. This court disposes of the instant petition with the liberty to the petitioners to avail remedies under Section 9 of the Act of 1971. It is made clear that this court grants 12 days time. This court, it is made clear that the petitioner's hearing, this court makes it clear that if the petitioner's hearing approaches the district judge Karbi Anglong within 12 days from today, the appeal so filed shall be heard on merits without insisting on the question of limitation. The interim order passed hearing on 22/6/2017 shall continue for a period of 12 days, that is 18. In 29th of September 2023, the learned district judge Karbi Anglong, this court further observes that the learned district judge Karbi Anglong shall decide such appeal without being influenced by the observations made herein. If so fine.
name show करा
Hmm?
नहीं petitioner name show करा नहीं
Very good. It reveals that the names of the petitioner, the council, names of the council for the petitioner have not been shown in the cause list. Accordingly, the registry shall direct it to list the matter after 2 weeks, indicating the names of the councils for the petitioners.
Kindly take up the IA 2805. The difficulty that we are facing is at page 45. Pursuant to the lawsuit order, we have applied to the authorities of the bank for liquidation of the FD. Now, the bank has returned back to us with this letter. They are of the view that they are maintaining this particular bank guarantee for the kind of the FD in view of the interim order that was passed. The interim order is at page 50.
Now, what are you trying to do?
What
This
they are
could
saying-
help
Okay.
you had a you had a petitioner.
Yes, sir.
Okay. Now,
What had happened was the interim order that was initially passed,
Hmm.
initially was stated, there was a stay order. State that you will not go to 40, but there was a condition that upon us also, you have to maintain a bank guarantee. That will also be found at page 16, that was the interim. Based on that, we had maintained a bank guarantee, which was ultimately converted into an FD. That will also be found at page 20. Now, the FD condition that the bank has given is, we are going to maintain this FD for all future contingency liabilities that may come pursuant to this honorable court order. So based on that, the bank has maintained the FD. Now, after you launched the passed an order, whereby the revocation was set aside, we approached the bank. We told them that there is now an order from the bank, from the High Court, and accordingly, you kindly liquidate our bank guarantee. Now, what the bank says, this is our FD is pursuant to the interim order of the Honorable High Court. That will be documented at page 16A. The operating procedure is 16A.
how does the PNB bank come into the scene?
Yes, that will also be find again. There what has happened was the entire liability was transferred from Allahabad Bank to PNB Bank. Those documents I have annexed on page 20.
Then,
The hospital kindly come to page 20. Page 21. The letter of Allahabad Bank. These are all the part of record of the initial PD. transferred the entire liability to PNB Bank.
How?
This was the bank transaction. This,
But that bank is not, PNB was not a party to that procedure.
yes, that is, PNB was never a party to that.
So
But
isn't this a fresh cause of action?
My limited trade philosophy is, if the
I may
interim order
only
has been
clarify one thing. That the interim order passed earlier shall not come into the here for the bank, for the petitioner to approach the concerned bank. That's all.
That is what I'm saying, though. Because the bank is saying, till the interim order is there, that I have to maintain a bank guarantee, and that has not been interpreted by this honorable in the final judgment. We were able to tell them that it has heard, but then they want some clarification on that regard.
What are you asking of him?
I'm praying that the interim directions that were passed in the order of 28/4/7, even though you take it, only to that extent. sir. That interim order is at case 15, operative portion is 16A.
What do you mean by merging? The interim order merging out here?
Also, normally when a logic was better, all interim orders would merge with the final order, final judgment.
Now, if it merges, doesn't the interim order remain?
The interim order gets merged, or I would mean that the judgment, the final judgment is the final word on that particular issue. The interim order will have no applicability in view of the final judgment will pass. So
That is a different aspect.
it gets
But if you say to merge, means
subsumed,
it
it
remains.
gets subsumed.
It is merge or subsume itself. It's nothing but a synonym of the earlier.
Yeah, yes, sir. But my understanding or my legal knowledge is all interim orders will lose its applicability in view of the directions passed in the final judgment. So in that view of the matter, that was what was being informed to the bank, that the interim order now gets merged with the final judgment. But then the bank requires the clarification on the regard, because the interim order was that we will have to maintain a bank guarantee. Now, that aspect has not been clarified or for the matter vacated, and so that is the technical difficulty we are facing with the bank.
The instant application has been filed by the petitioner as applicant. In view of a confusion having arisen, as to what is the effect of the interim order pursuant to the order being passed by this court, pursuant to the judge, as regards the interim order, effect of the interim order dated
28/4/2007, it is 15.
28,
4/2007.
28/4/2017. Pursuant to the judgment and order dated 5/8/2023 in WPC number 2499/2017. This court clarifies that the said interim order dated 28/4/2017 passed in WPC number 2499/2017 loses its existence pursuant to the judgment and order dated 28/5/2023 passed in WPC number 2499/2017. Taking into account the above, the instant applications.
In so far as maintaining of the bank guarantees loses its existence.
I said it is loses its existence.
Velocity. In so far as the maintenance of.
Why?
bank
That is not the question before this court. The moment you say that, the thing is that how can I pass an order when the PNB is not a party?
This order will not be against P and B.
Understood, but you are against that letter.
That's true.
You are only asking what is the effect. I said that it loses its existence pursuant to the order. Judgment past tense. Now I think you may clarify if it is not done. I think it will be a case of a second repetition. It will be a fresh call of action.
If that words are included, so far as maintenance, because the interim order says to maintain the bank guarantee. So it loses its existence. Clause will just add this line, is so far as maintenance of the bank guarantee is concerned. It becomes very specific and I think we will be safe from another litigation. Only the respect for the loss consideration. It makes it very clear there.
তাতে লেখো এনেকে so এই কনফিউশনৰ কথাটো কৈছে for which the instant application has been filed. Absolutely লেখো. A perusal of the interim order dated 28/4/2017 passed in WPC number 29499/2017 shows that this court state the letter dated 25/4/2017, subject to the condition that within 1 week from the date of the said order, the petitioner would communicate to the respondent number 1 to 3, intimating that the validity of the bank guarantee in question have been extended beyond the next date fixed in the case. The said interim order had been extended from time to time and it is also seen that this court, while in its judgment and order dated 5/8/2023, had taken into account at paragraph number 12 the communication issued by the branch head of the Punjab National Bank dated 27/9/2018, wherein it was provided that the lien has been marked against the fixed deposit of 75 lakhs of the petitioner against the contingent future liability towards APDCL, subject to this court's verdict in the instant case. Further to that, it was also mentioned, it was also certified by the branch head of the Punjab National Bank that a bank guarantee towards the APDCL for the amount of rupees 75 lakhs would continue to remain subsisting and in existence till further orders of this court. Discorded by the judgment and order dated 5/8/2023 had held that the impugned letter dated 25/4/2017 to invoke the bank guarantee had set aside the impugned letter dated 25/4/2017 to invoke the bank guarantee. As well as the forfeiture of the entire bank guarantee. In view of the setting aside of the impugned letter dated 25/4/2017, which was stayed by this court by the interim order dated so and so. Nothing survives. The interim order so passed on 28/4/2017 loses its existence. And as such, the question of extending the validity thereupon does not arise with the above extent.
Validity of the bank guarantee.
It is enough. You file another requisition, please.
For a bank guarantee, what is the price? Like, okay, all right. Give you that.
What actually is second number one? Order say right now.
Yes, tell me. Huh?
Found the provision of the Assam National Highway Act and the Arbitration and Conciliation.
Assam National Highway.
National Highway Act and Arbitration and Conciliation Act. But trying to submit my lord. Other than the 3G6 of the National Highway Act.
Yes.
3G5 says, my lord, if an amount determined by the complaint authority under subsection 1 or subsection is not acceptable to either of the parties, the amount here on an application by the either of the party be determined by the arbitrator to be appointed by the central government. And my lord, 6 says, my lord, subject to the provision of this act, the provision of the Arbitration and Conciliation Act 1996 shall apply to every arbitration under this act. So now, my lord, if we now come to the Arbitration and Conciliation Act, my lord. Now, my lord, I will take you to section 5, my lord. Section 5 says, my lord, extent of judicial extent of judicial intervention. Not seeking anything.
Shall not be made unless it has been mentioned in part 1.
Yes.
Then?
And my lord,
Then you are referring to section 37.
I am section 17. my lord.
Yes, 17 says what? Huh?
Interim order, my lord, by the arbitration.
No, there is no quarrel.
And
Quarrel with the fact that the arbitrator can pass an interim order. There is nothing to that effect. But tell me, did you ask for that interim?
yes, my lord.
Where is it?
You are filing a petition there, my lord,
Where?
for the arbitration.
No, you must have enclosed out here. Your application does not say so.
I make a statement, my lord. Document my idea, my lord. And
Show me, you must be having a copy of it.
yes, my lord.
Yes. Show me. Yes. Yes, tell me.
There, I have also mentioned my, idea, my lord.
Okay. No, understood. But the property by virtue of section 3D rests upon the state.
Yes, my lord. But my lord, under section 17, my lord, after section 17, my lord, the arbiter has completely power, my lord.
Power to what? Look, no, when the question does not arise, is it your final relief?
For a hand-
No, what is your final relief? The final relief is only payment of money.
Yes, my lord, but
Then-
what you have mentioned in our.
No, understood, but then also, if it is the amount, if this continues, and do you, Mr. Alam, are you aware what is going to have the consequences thereof? In all cases where a reference is made, if the proceedings are to be stayed, the acquisition proceedings are to be stayed, do you know what is going to be the consequences?
We are not saying that. We are only saying, because I have seen.
You are saying that this may be done, but how can it be done when there is no arbitrator? That is the problem which is happening.
The order was already passed, my lord.
Oh, can it be done? Now, where is the order? Final arbitration award has been passed.
No, my lord.
Then that is why I am saying.
My lord, can you see, my lord, the last page of the idea, my lord, and the, my lord, that page, my lord,
Page what?
page, my lord, page 14, my lord.
Yes.
Now, can you see that word character, my lord?
Hmm.
I have gone for the petition, sir, I have compared to necessary for the record. The expedient to direct the unit of the income tax to assess the market value of the building house structure of the petition at the rate of legal and transfer, that is the date of publication of the petition of the National Highway Act. Further, for assessing the plan sheet of the terms of the land and planning regulation, the deputy commissioner, Cardinal Law in association with the division of police officer, Cardinal Law and Peace, and Mr.
Mr. Alam, I understand. Has the arbitration proceedings culminated? No. If it is not being culminated till now, so the arbitrator has to take a decision as to what would be the adequate compensation. Then,
Right now, my lord, things are what I'm trying to find out. Because of the order, my lord, the subsequent letter part, not before in the order, but letter part already it was assessed and before it was submitted, because people were going to my place. My lord.
then also, don't you think the arbitrator has to pass an award in view of 386? They're saying that, yes, he is entitled to this amount. Without that amount being done, can it be done? Now, as of now, there is no arbitrator.
Under section 6 of the Arbitration Constitution Act, my lord, there is a provision, my lord,
For expert opinion. Mr. Alam, there is no quarrel with this proposition, those things. But the arbitrator has done this under section 26. There is no quarrel with. But don't you think that the arbitrator has to pass an award? If the award is not filed, is not passed and delivered to them in view of section 31(7), read with section 32, the proceedings does not terminate.
now, so the, now, my lord, please, suppose, my lord, tomorrow, my lord, my lord, I will show from the, this, we have been filed, my lord. Page 70.
No, it's okay. What is the consequence if the building is demolished?
Home, my lord.
So make the measurement and I'll direct them.
That's what we want, my lord.
So they before demolishing, they will make the measurement.
We want that only, my lord. That is
You are not asking, you are asking for vacating.
modifying, my lord.
No, not modifying. Are you asking that?
Yes, my lord. Can you see my prayer, my lord? I want to change that, my lord. You are not against, my lord.
No, not to assess. Directed to assess the market value. These market value assessment nothing to do. They are going to only take photographs and make the measurement. That's all.
Yes, 11, my lord.
Before demolishing, that is the only thing they are doing.
Yes,
What measurements are required?
11, my lord. Now I will show you lottery, my lord. Kindly see, my lord. Now that how the measurement is wrong, my lord. I will just show you lottery.
No, Mr. Alam, I'm not going to do all these things because this court someday there is no chance of this court at any point of time being a divisional commissioner
My lord.
or a revenue department. so that chance does not arise. So under such circumstances, this court is not going to do. Tomorrow, if you are agreed, you may file an appeal under 34 before the district judge. And then it may come before this court sometime another 10, 12 years, I may retire by then. So then in that regard, we can say. But as of now, there is nothing to do.
Measurement by the independent agency.
Huh?
Measurement may be done by any other agencies other than Maharashtra.
What measurement?
But the measurement, they have done.
Measurement for what?
Measurement of the building and the structure.
You have the blueprint.
Or
You have the blueprint.
I have the one of valuation report where it's.
Oh, very well. This valuation report shall be taken into account. That's all. You have a valuation report saying all these things being certified. That is a question of evidence which the arbitrator will look into it. But are you going to say that this arbitrator will send this person concerned and make the measurement? No, these are not to be done in this manner. Whatever you are to show, because you are the person who is agreed with the inadequacy of the compensation. So under such circumstances, it is you who have to show it, you have to prove it. And as regards the land value, are you agree with the land value?
We are not on land value, we are only on the building structures.
So building constructions, if it is there, you take photographs before that.
A photograph never be able to find out the dimensions of the measurement of the land. Because
What do you want?
we want the measurement to be done.
What measurement?
Measurement of the structure, how this, two or something, how the non-building is there.
Mr. Alam, why should this court give you an exception for that? For a measurement to be made for some other agency which is not being done for anybody else? Tell me, give me a good reason why. Because you see, this is not a one time for you. Tomorrow, your case, if it is done, somebody else will come. And every time this will be a huge problem. So under such circumstances, you have a valuation report that you submit it. You take photographs, submit it. They may, before building, Mr. Talukdar, before demolishing the buildings, you make whatever measurement as per your person. You show yours, he will show yours, the arbitrator will decide thereupon. That's all, nothing more than that. But this matter, I am only keeping it pending. I would have to dispose it out there because the arbitrator could not have passed that order. Be there an impact on the first day, I did not. I want to dismiss his requisition. And I gave it to be placed before another judge, if it is so. But the fact that again, bad luck had it, it again came back to me. So that is why. Now, the fact that in view of section 3B, the property now vests upon. You cannot do it because that is the operation of law. Unless and unless you challenge the entire acquisition proceeding from 3A, which you have not done. Your application only shows that you are with the inadequacy. So you have your own valuation report. Very well, do it. He will have his own valuation report. You will make some measurement. Yes, you are there.
As per the section 29 of the 2013 measure,
Mm.
it is by the competent engineer. That word is competent engineer. Accordingly, the by the Tala PWD department took the measurements and the valuation is done on the basis of date of
So
construction.
you have made the measurement.
Date of on the basis of GIA was determined that has been deposited and that was by the deposited before the Tala. Subsequently, by the petitioner filed a repetition by the India High Court and the repetition that was sent to the arbitrator. At that time, during that period, when there was the no stay of the court, they reconstructed the house. We have annexed all those photographs in the earlier repetition. That was done by the petitioner. We have annexed all those videos subsequently.
You constructed the.
And we have by vote affidavit, and we have that is a part of the record of earlier repetition. And
The question of doing all these things, modification does
we have
not.
already determined a complexion amount as per the section 29 of the 2013 by the competent engineer of the department.
The instant application has been filed by the petitioner. By the respondent numbers, econo respondent number given over. By the applicants who are the respondent numbers 10 to 13 of the petition, econo by the applicant who is the respondent number 10. You have filed two, only one. Respondent number 10 to 13 by the applicants who are the respondent number 10 to 13 seeking made modification and seeking vacation oblique modification oblique alteration of the order dated 13/9/2023 passed by this court in WPC number 5205/2023 and further seeking a direction upon the authority indicated in the order dated 2/5/2023 to assess the market value of the applicant's residential house and structure standing in Dag number 203 of KP Patta number 63 under Muza Langpar in the district of Karbi Anglong, Assam, or alternatively, the say aforesaid may be assessed by any other independent authority. Full stop. This court, by then order dated 13/9/2023, had stayed the order passed by the interim order passed by the learned arbitrator dated 19/4/2023 only to the extent wherein there was a direction to the respondents' authorities not to demolish the residential houses, structures and trees on the land covered by Dag number 203 of KP Patta number 63. This court have done so, taking into account that by virtue of Section 3D of the National Highways Act 1956, and more particularly, subsection 2 of Section 3D, the subsection 2 of Section 3D of the said Act, the land vests absolutely in the central government, free from all encumbrances, with the issuance of the declaration, with the publication of the declaration in terms of declaration made under Section 3D of the National Highways Act 1956. This court had also passed the interim order, taking into account that it is taking into account that the petition, that the applicants the respondent numbers 10 to 13 have not challenged the acquisition proceedings, but rather have approached the arbitrator under Section 3G5 on account of inadequacy of the compensation and have sought for enhancement of the said amount. This court had also taken note of that in view of the stay order dated, in view of the restraint order passed on 19/4/2023 by the learned arbitrator in the arbitration proceedings, it has resulted in stoppage, in interruption of the works, thereby affecting the public interest, which in effect would lead to escalation of the prices. Today, when the matter is taken up, this court had put the question. Yes, now I'm putting the question. I will state, you say that any escalation price you will indemnify. Tell me, you indemnify them. They have no problem. Any escalation which is done because of you will be you. I'm going to do it. No, Mr. Alam. These are public. I would have understood if you have gone for a challenge to the acquisition procedure. This, you are only question of money. You may get more money, less money, whatever. But you are stopping this. I am therefore putting a specific query to you. If you are willing to indemnify the respondent authorities for any loss which has occasioned during for the stay or vacating the stay, you are going to bear it. No, are you going to do it or not? You have already got 1 crore. No.
They have given me 27 lakh.
Okay, 27 lakhs is also fine money.
64 lakhs.
Anyway, 24, 64, whatever may be, that is the amount. And further, there will be more escalation prices. Are you going to do that?
I plan cannot do other. Because my lord,
This court, during the course of the hearing today, this court put a specific query upon Mr. G. Alam, the learned counsel appearing on behalf of the applicants / the respondent number 10 to 13, as to whether the applicants / the respondent numbers 10 to 13 is willing to indemnify the respondent authorities, the petitioners, whose were the petitioners, for the loss which would occasion on account of the stay, on account of the order dated 19/4/2023, if allowed to remain operational. The learned counsel submits that this client is not willing to indemnify the respondents, the petitioners in that regard. This court had also taken note of that the application so filed by the applicants, that is the respondent numbers 10 to 13, is for the purpose of enhancing the compensation, meaning thereby the question involved is as to whether the applicants / the respondent number 10 to 13 would be entitled to an enhanced amount or not. Under such circumstances, as it is a question of money which is involved, it is the opinion of this court that it would not be a condition that any irreparable loss, harm, and injury would be caused to the applicant / the respondent number 10 to 13 if the order dated 19/4/2023 is stayed. Under such circumstances, this court does not find any ground for the purpose of modifying, altering, or vacating the order dated 13/9/2023, passed in the accompanying petition. This court further points, before concluding, this court also finds it relevant to take note of that during the course of the hearing, Mr. G. Alam, the learned counsel appearing on behalf of the applicants / the respondent number 10 to 13, had submitted that there is a valuation report available as regards the houses standing over the lands in question. Mr. J. Shutia, the learned counsel appearing on behalf of the Kala, submits that in terms with section 29 of the Act, of the Act, right to fair compensation and all these things of here, the competent authority through the
engineer of the public works department of government.
through the competent authority through the public works department, through the engineer of the public works department of the government of Assam, had duly taken note of the measurements of the houses standing over the land, and in that regard have over land as on the date of the declaration made under section 3D of the
Now we have taken measurement on the basis of the date of construction of the house.
No. When did you take?
At the time of publication of 3D.
At the time of the declaration made under section 3D of the Act of 3D of the National Highways Act 1956. Because these are aspects of the matter which requires to be adjudicated upon by the arbitrator. And as such, this court deems it would not like to go into such details which may affect either the applicant's hearing or the respondents at the time during the arbitration proceedings.
3F of the NE segment.
Eh?
3F.
3F.
The right to enter, my lord. When the 3D was published, my lord, was to use 3F of the Highway Act.
No, you did when after 3D, na?
3D, my lord.
Immediate.
Under the section 3F, my lord, after publication of the 3D document, central government have the power to enter the land and construct the, my lord. Construct the road.
So you have done after, that is why I have recorded after 3D.
After 3D.
I still discussed. To be listed, a main repetition, the matter be listed. It will main repetition for there, it is the statement. The matter be listed again on 16/10/2023 as directed by the order dated 13/9/2023. The accompanying repetition be listed on 16th as directed by.
Article 9.
Yes. What is this?
Regarding
Washing and cancelling the illegal and arbitrary transfer of holding number so and so in favor of Radha Sharma, who was here. Who has done that?
I am the owner and I'm my wife. The house was constructed and it was included in the two holdings. Holding number 170 and 171. And this house falls under 3 dogs. And after 1990, in 2002, I and my wife sold. I sold 14 and a half acres of land, and my wife sold 6 and a half acres. So, my 1 acre of land was sold. And hereafter, the major portion of the house included the sale matter. There is 14 and a half and 14 letter, 14.5 letters and 6.5 letters. So my lord, the rest portion that remained under our possession, and then I applied for the municipal board that keeping my holding in respect of the portion of the house under our possession.
How do you say that there has been a transfer? Where is the document?
Transfer the holding, transfer of the holding, the document law, nothing of fantasy, that is NSR 14. NSR 14 has page 35. There in Radha Sharma's name, tax was paid, the tax was received by knowledge municipal.
In respect to which holding?
In respect of holding number 170 and 171.
Where is it?
Here it is not reflected.
Then, if it is not reflected, why? How can this court say that there is a transfer in the name of Radha Sharma? Yes, you come to that one.
I and my wife, they applied before the municipal.
Mr. Chaudhary, your matter actually comes within the purview of civil suits. You and Radha Sharma is the problem. You are dragging in the other people. Mr. S. Goswami, you are appearing for Radha Sharma.
No, municipal board.
Okay. You are unnecessarily dragging Mr. S. Goswami. Although he would not mind, that's a different thing. Huh?
and 800. And 26 and 28.
Hmm,
Mother, I applied before the municipal board, mother,
hmm. For what?
that in 2002, Sonaram Datta and Logan Datta purchased the land. Mother. I am reading these things. In this way, I will say that I have sold land.
Paid before your honor to assess the house tax in respect of Iman at the earliest I can pay the house tax within time. So
And
this is of 2004.
2004.
Then,
Thereafter, my lord, thereafter, I applied for, mother,
when did you get that number, the holding number 170 and 170? When is your assessment?
in 2000, in 1990, mother.
Then,
I applied for the, then I knew a lot.
now where is that in your name? 190 and 170 and 170?
I have paid tax, mother.
What?
Annex 1 to 4, my lord. This is the tax, mother. These are the tax.
Susila Jain,
Silavan is my wife and Komal Kumar Goel is myself.
your name is?
Komal Kumar Goel.
Komal Kumar Jain. Ward number 6.
Yes.
Okay, now, are you still paying tax?
No, no, mother. They,
Why? Why they have not received it?
they did not receive it because
Where are you mentioning? They have not received it. There is nothing on record to show that they have done anything to that effect
mother, I applied for certified utility assessment also, mother.
of your assessment.
Yes, ma'am. In by NSN 9, case study. Mother, I submitted so many representations before the authority, the municipal board. Only municipal.
Why you are, first of all, this court has to be clear that you have, that there is a dark number 170 and 171 in your mayor payment out there does not show.
Only number.
Yes. Where is it? Nothing.
My,
Now that the 170 and 171 is in the name of the respondent number 7. Where is it? Nothing.
only whether my application, your lordship.
Yes, Mr. Goswami.
I submitted.
Can anything be done with him or should I dismiss it on that?
Already there has been sold by him because purchased by another person. Therefore, another person sold it into that's number 6.
That's one number 7.
Sonaram Datta transferred it to restaurant number 6.
Or that's one
So,
number 6.
only along with the house. So thereafter, it is transferred immediately to the name of the person.
Where is the sale deed?
They have no debit.
None. Nothing remains.
Change manager.
No, Mr. Nothing. Have you sold this land to anybody?
Sonaram Datta.
Where is the sale deed?
That's something that I haven't done.
Why haven't you not enclosed? No, but first of all, Mr. No, Mr. Chaudhary.
Development authority's permission, that has been annexed, annexed a file. That has been annexed, mother.
I think, Mr. Chaudhary, this is a fit case for issuance of a rule to be heard after 10 years.
Mother,
This is not a fit case. No,
Only.
there are two ways out. Either you escape this for next 10 years or dismiss.
Certified copy of the
No,
assessment,
no, no.
mother.
These are nothing is there.
Board,
Nothing is there. You
Only,
don't know the
mother, only the direction.
Mr. Chaudhary, what do you want? I'm not going to pass any single, I can only say issuance of, admit this petition to be listed for hearing in 2029.
Mother, you will not do anything, mother.
So then the next course of action is admitted,
I-
dismiss, and the third course of action is withdrawal with a liberty to approach the authority. With 3 of it, either of it, I'm giving it.
Mother,
3.
municipal board pay is for my representation. mother.
No, I would not give it unless you have produced the sale deed. Why haven't you produced the sale?
I will be allowed to, allowed time, by an additional.
Mr. D. Chaudhary seeks for an accommodation. This is the matter after the puja recess.
I'll file an additional permission.
Not necessary. You don't have a case as of now. 11. The learned counsel appearing on behalf of the petitioner submits that he has instruction not to press the instant petition, for which the instant petition stands dismissed on withdrawal. Mr. Borua, kindly give your name in that other matter which
I already,
yes.
here I'll tell you.
I've again dismissed that application, but one thing good, they have appeared. I stands the petition stands dismissed on withdrawal. And interim order is there.
Well,
Yes, Mr. Bhuya.
About the mayor police for accommodation.
Yes, please. I don't have time today. Huh? No. We'll have it after vacation. At the request of the Learning Council for the petitioner, matter be lifted after vacations, to the vacations. It appears on record that on the earlier occasion also the petitioner was not represented. Because it seems that the petitioner is not interested in the proceedings for which the instant petition stands dismissed for non-prosecution. Okay. Any level? None has appeared on behalf of the petition. Because on the earlier occasion also, that is on 27/2/2023, none has appeared on behalf of the petitioner. On the other hand, Mr. V. Chaudhary, appearing on behalf of the APDCL, submits that the matter have been resolved, and in that regard have placed a communication dated 29/2022 issued by the CGM brackets COM and to what in EE bracket close APDCL. The said communication is kept on record and marked with the letter X. It therefore seems that the petitioner is not interested in the instant matter, for which the instant petition stands closed on the basis of the submission made by Mr. B. Chaudhary, as well as the document enclosed and kept on record, and the document kept on record and marked with the letter X.
14.
Yes, Mr. Das, in what is this? Oh, is it? Why is it become infraction?
Because the original owner,
Ah.
he has taken over this garden matter. On by the agreement, entering between the the employee for operation. Now he is making payment of the area transfer.
Who is Ranjana Das? Who is Ranjana Das?
Some part of the garden matter, it's only matter.
So that has now been taken over by who was granted, who had granted the lease? None appears on behalf of the petitioner on call. On the other hand, Mr. N.C. Das, the learned senior counsel, appearing on behalf of the Assam Tea Employees Provident Fund Organization, submits that presently the tea estate is being run by the original owner, and as such, nothing further survives in the instant petition. In that regard, he has placed an instruction issued by the Secretary cum PF Commissioner dated 18/9/2023, which is kept on record and marked with the letter X. Taking into account the above, the instant petition therefore stands closed as infraction. Who are you? Who are the original owner?
I'm not the owner, I'm the receiver. I was the receiver and my agreement has been already over this company.
So Mr. DJ Das, I report close Mr. DJ Das the learned counsel appearing on behalf of the respondent number 4 and 5 also submits that he was initially appointed as the receiver, and in view of the taking over of the tea estate by the original owner, his receivership has also been terminated. In that regard, he has also placed an instruction which is kept on record and marked with the letter Y. That followed like, but taking into account that none has appeared on behalf of the petitioner on call, the submissions of Mr. N.C. Das, the learned senior counsel, as well as Mr. D.J. Das, the learned counsel appearing for the respondent number 4 and 5, as well as and the communications which have been kept on record and marked with the letter X and Y, nothing. It is the opinion of this court, nothing survives in the petition for which the petition stands closed. Interim order was there?
No.
15. So, verify and pay. Chief engineer, within 4 months. Verify, pay within period of 4 months. None appeal. Yes. E-tender, what remains? Nothing remains. Huh? The work was for? Okay, nothing remains. Mr.
After filing of the WPCA as per the subsequent document, the Union Authority created awarded to one seat.
Let you challenge it. The learned counsel appearing on behalf of the instant writ petition was filed challenging the order dated 22/1/2018, whereby the respondent number 3 disqualified the petitioner from the contract and also directed and also to direct the respondents to allow the petitioner to participate in the tender process so that the petitioner's bid can be reconsidered on the relevant criteria. It has been submitted by the learned counsel for the petitioner that pursuant to the filing of the instant writ petition, and the stay so granted, the said notice inviting tender has been withdrawn, and thereupon the fresh notice inviting tender has been issued. Taking into account that the earlier notice inviting tender, on the basis of which the respondent number 3 had taken the decision to disqualify the petitioner, have been withdrawn, nothing survives in the instant writ petition, for which the instant writ petition stands closed as infructuous. Interim order so passed has also the interim order so passed also stands vacated accordingly.
17.
Yes. What remains in this case? Inviting manufacturers of tractors, afresh and others. What happened? No stay. So nothing remains. What happened to the contract?
Contract is the parcel, and under a particular scheme, that was a subsidy was to be given. Subsequently, that was remodified and in 2018, because initially started in 2007. CNS, the petitioner has now said in 2018 modification. Saying that we will not get the benefit as they have.
Okay, none appears on behalf of the petitioner on call. Mr. M.K. Mishra appears for the respondent number 6. This court fixes this matter again on 25th of September 2023. It is made clear if the petitioner is not represented, the instant petition shall be dismissed for non-prosecution. 18. Nobody is bothered. These type of matters have been already given. Who is appearing? None. Huh? PNRD, nobody is appearing. Mr. Bhuiya was here sometime back. Okay, none, very agar order to didi, huh? Koशिश देखिए fix कर. We'll dismiss it. 19. Yes. What is this matter?
This is the matter where I depend on the other people. He demanded for the call that something has been have to be given by the bank.
Why?
That we have not prepaid in the amount which have been deposited by the customer. That is the allegation. But thereafter, you also get I don't know affidavit. And that affidavit, you understand that there is an allegation of this for the temporary of evidence. My affidavit shows there is not constituted. I might comment it. However, it also be in related to this.
Hello, we'll have it after puja. What do you say? This is the matter of the puja vacations. 22. Hello, Kana, Gulia, Kongini.
Where the petitioner is a basic customer and the consumer, he has running three factory matter that Nadi Ratna on 29/5/2018.
You are challenging the appellate order.
Yes, sir.
I've got to stay. Are you getting a stay? Have you got a stay or not?
Madam, I got it.
You got. Now this is continuing
Yes, madam.
and the PDCL is not interested. Chalo. None appears on behalf of the PDCL on call. Yes, what do you have to say? The PDCL runs.
Madam, the admission still, madam. But that admission still, madam. Because, madam, the
Okay. List the matter, taking into account that the pleadings are complete. List the matter on 21st of November. Final disposal at the admission stage.
31.
None of the parties have appeared before this court when the court matter has been called. For the end of justice, matter stands adjourned to be listed after 4 weeks.
26 to 30.
Yes, Mr. Samaria. On payment of which department? Huh? PHE. Why do you need pleadings for all these type of matters? No PHE. How much we are asking for?
Hello, there are 5 cases, almost 1 crore.
One, huh?
5 cases cover 1 crore.
Well, and what is their reply?
Hello, there is, there disputing the figure, some amount they have admitted. But rest amount they are disputing, they are saying that case was completely over. So if sector 67 protect very much, the 37 will not be met. It is running bill matter. We are not found out some complete. That is just based on that they have cancelled our work.
They've cancelled your work order. Then how do you get it?
One of the first stage I have completed. We read the field, that is not been.
No, how can all these things be decided here?
But
226.
it's very clear, madam, that there is a running process there. We have.
No, if it is a running bill, it is a contractual matter, why should we do it? They say that they are not entitled to. Why should this court under 226 look into all these things?
So only earlier days, because it also contain arbitration.
Arbitration rules.
Yes, madam. Not
Then-
by dealt with this matter and also finally come to this conclusion that because there is a proposal which is the cancellation process which they have initiated because proposed notice, therefore it takes matter in the right of independent.
Did I? Where is my order?
But the order, notice on that they have this matter and they have to directly the other side to submit their reply.
Oh, yeah. On the occasion, on the last day, SP Sharma, the learner sought for 2 weeks' time and this court granted the financial to them, Mr. Goswami, the addition advocate had placed on record an instruction issued by the district so and so, wherein out of the 9 works mentioned in the petition being so, only instructions have been received in respect whereby the PHA have duly admitted 22 lakhs is pending due in respect of the said 2 works. However, in respect of all other works as mentioned in the 2 petition, there were no instructions. And so and so, according to his opinion, the final chance may be granted to the PHA to file the affidavit on or before remand, failing which they shall be constrained to direct personal appearance. Then they filed the affidavit.
Yet the Lord Support 10/2022 had this matter on the basis of the issue.
Who heard? I heard. Okay. And Mr. Samaria submits that he would like to file a reply to the affidavit in opposition filed by the PHA.
On that day, this matter was heard on the.
How can I hear when I have asked you to file an affidavit in reply?
Afterwards, it was allowed, after getting the both parties.
Then what happens?
But there they file affidavit, we also file a reply, it's ready for it.
Then how can this court decide all this?
But it is very disputed that.
Huh?
There is only disputed that. It is only that they want to say that we have not completed the work, that's why they have cancelled our work. That case has to be done by.
The PHE is not represented when the matter has been called. To stop. For the end of justice, the matter stands adjourned to 16th of November 2023, on which date an attempt shall be made to dispose of the repetitions. It is made clear that if the PHE is not represented on such date, this court shall dispose of the matter ex parte. Ms. S. Burwa appearing on behalf of the respondent Deputy Commissioner. So request for an accommodation for a week to obtain the instructions in terms with the order dated 25/8/2023. List the matter again on 29th of September 2023, on which state Mrs. Burua shall ensure that the instructions sought for by the order dated 25/8/2023 is received.
33 to 35.
None appear to take it. Mrs. Burua, you are also there here in this matter. You are filing. Ms. S. Burua, appearing on behalf of the District Commissioner South Salmara Mankasa, submits that the respondents shall file their affidavit during the course of the day today, pursuant to the direction path which is scored on 23/8/2023. List the matter again on 4th of October 2023. We filed the affidavit today.
36.
Yes. Yes, forest, nobody for forest. This court had directed the petitioner to file an additional affidavit on 11/8/2023. However, the said additional affidavit was not filed. On 21/8/2023 also, this court had directed the petitioner had granted a further accommodation for filing the additional affidavit. It reveals from the records that the said additional affidavit then also has not been filed. It seems that the petitioner is no longer interested in the matter. Be that as it may, this court for the ends of justice grants one additional opportunity to the petitioner. Accordingly, list the matter on 25th of September 2023. It is made clear that if the additional affidavit is not filed or the petitioner is not represented, the instant petition shall be dismissed for non-prosecution.
38.
Ask the people,
Oh, that matter. Yes, any information? Affidavit in position filed by respondent number 5. So any information pursuant to that order? Mr. S. Bhattakur was to obtain instructions in that regard, no? For who was appearing for respondent number 5? He directed to submit a report. Yes, madam. Respondent number 6, who is appearing for the Circle Officer Kamrup? Oh. Ms. S. Burua, the learned counsel appearing on behalf of the Circle Officer Kamrup Metro, had submitted that in spite of the communication given to the state officer as regards the order dated 21/8/2023. The circle officer Kamrup Metro have not responded. We call him for personal appearance. Huh? No, you have communicated, they have not done it. Then have not responded to the request so made by by Miss S. Burwa, appearing on behalf of the circle officer Kamrup Metro. This court fixes this matter again on 25th of September 2023. It is made clear that if the circle officer, Kamrup Metro, does not submit the report in terms with the order dated 21/8/2023, this court shall be constrained to pass appropriate directions for his personal appearance. Madam, last time I passed an order, taking into account the above, the question of interim order to be extended does not arise. How can